So now we are going to talk about navigating exits. I think that's another very interesting subject. And let me quickly start with Pratibha, maybe. I know it's a fag end of the day, long flight, but you have been handling large private equity litigations in India. What, according to you, are typical exit challenges faced by the PE investors?
Sure. I ended up doing litigation just by default because, once your client's in trouble, your client's in trouble, and, whether you're a litigation lawyer or not, client needs your advice. And we've actually helped actually significant portion of our private equity clients in very difficult situations in India. And it's been a great learning because the last few years have been a painful part of the investment cycle in India, globally. But that's when you learn your lessons. And I think for me, being an investment lawyer and then looking at it from a dispute perspective, the first eye-opener was the importance of a dispute resolution clause in India. It is not standard. It is not to be negotiated at the end as the last 12 generic clauses. It is probably, given it's a very litigious industry currently, it is something that should be taken very seriously. We ensure that our disputes team looks at each and every dispute resolution clause in any contract. We don't have the investment team looking at that. We actually get our disputes team involved. We've had recent changes in our Arbitration Act, which is more foreign investor friendly now. In terms of giving you the options. Earlier, the optionalities were limited in terms of jurisdiction of Indian courts. Now you can completely choose to exclude Indian courts, but you have to decide whether or not that's what you want, depending on whether your client's going to be wanting interim relief in India or not through Indian courts. So it's not a standard, let's take everything out of India, which is the preferred approach. Everybody in India, for foreign investors, we all seem to prefer SIAC. But whether or not we exclude Indian courts depends on the facts and circumstances of the case, depending on whether your client will need to immediately enforce something in India or not. Second most important realization we've had in the last few years is how fair have you been with the promoter in the contract? It's not always a good thing, and the investment team might not like this, but it's not always good to have a contract that you've negotiated where your conversion ratio for your CCPS will make you theoretically own the company upon happening of certain events in the next 3 years. That is not the outcome that the promoter is expecting, and if he's not expecting but still goes ahead and signs it, in his head he's thinking, doesn't matter, I'll screw them anyways when it comes to it. And he starts working towards doing that because he has this clause that he's worried about in the agreement. So we've actually realized it's better to have a fairer contract where there's less incentive for the promoter to start working against you and start conniving on how to work against you. Because believe it or not, I've had very respect for Indian promoters come back and say, okay, fine, you want this in the clause, take it, but when time comes, I will go to the Indian regulator and say that this contract is not valid as per Indian regulations. And they always have that stick that they use against you. And ultimately it works in your favor, doesn't work in your favor, but delays your exit. And guess what? As a private equity investor, as a VC investor, you're time bound and they're not. Time is in their favor. It's not in your favor. And the way the Indian system works, it takes time. As soon as anything goes into dispute, now with the Arbitration Act, thankfully, you can do a time-bound arbitration, and we're just starting to test time-bound arbitrations. Literally, right now, we are in a few which are under the new act, have to be completed within 1 year. But other than that, if it goes into a regulatory review, scrutiny, or goes to courts, it can take a long time, and you've missed out on your exit. The third thing is planning your exit. If you know that you're coming to the end of the life of the fund, we have started advising clients on on a substantial investment to start talking to us a couple of years before. Because you've got to plan it out. There are going to be issues that need to be sorted. There's going to be diligence that needs to be done on the portfolio company to ensure, we've had cases where the right, even if there's no fraud on part of the promoter, the right filing was missed, and hence you can't do the exit till the regulatory issue is sorted out. And again, you're selling in distress because or to the promoter or the company, because you don't have any other option left. So start planning it ahead of time, at least a couple of years before, to ensure that there are not going to be any last minute issues to think about. Fourth, all the promoters at the end of the day are same. We've seen family-owned companies. We've seen so-called professional promoters in the last few years. At the end of the day, they all know you're the foreign investor, you're the PE investor with limited time, and that they have the upper hand, and they will try and renegotiate the contract at the time of the exit. So it's very important to recognize those limitations, and recognizing, like, we've literally seen the same strategy in terms of initiating disputes against investors by the promoters again and again in different deals, different promoters. They all seem to be talking to each other, believe it or not. And so, recognizing that, and recognizing the limitation of that you don't want to be known as the litigious private equity investor, VC investor, that is, and knowing that the promoter knows that. You've got to know, what you can or cannot navigate, and what you won't, or you can or won't do for getting your investment back. So, for example, we've had situation where clients said, we've discovered this issue, this fraud in the portfolio company. Send them a notice. You send them a notice, but then the client is not willing to follow it through because of the threat of litigation and the media focus that it can get on them. So you need to know how far you're willing to fight it, and accordingly settle or discuss the issue with the promoter. And fifth, and probably the most important, is the Indian laws, a lot of them have criminal sanctions for directors and even for people involved in the business of the company. You can be, the most commonly used provision is Section 420 under the Indian Penal Code, which is for cheating, where you don't need to be a director, you just need to be a person who's supposedly connived with somebody to cheat the promoter from his dues. And it can be completely false, but the fact is that there is a chance of getting a warrant against you, and then or your employees in India, and then you're on a back foot in terms of dealing with those issues. So that is something we highlight to our clients upfront when they're trying to decide who's dealing with the promoter, whether it's somebody based in India, based outside India, whether or not to put a director in the company. This is to go to what Richard was saying in the previous panel. It's not just about reserve matters, but also do you really need a director just because you're getting one? Can you achieve the same result through reserve matters and an observership, for example? And weighing the pros and cons of your information rights versus the pain of having to deal with liability issues for your employees tomorrow. Yeah.
Very good. Thank you so much. I think we almost coming to a close, but if you don't mind, we can spare 5-10 minutes more so we can finish exits. It's okay? Anyway, I take silent as consent. Okay. So, Ruchir, what are the regulatory hurdles in exits, PE exits, Quickly.
Yeah, I think clearly one of the challenges that everyone faces is in terms of assured return-based exits. So clearly, if you are an FDI investor, that means you've acquired equity shares or instruments compulsorily convertible into equity, then you cannot have an arrangement with an Indian resident that you would exit at a given price or a given IRR or things like that. So you cannot, as a non-resident, you cannot exit at a price more than the fair market value determined by any pricing methodologies. So I think one of the structures to avoid that or kind of get through that is that either you ensure that your exit, if you really want an assured return exit kind of structure, is that structure it in favor of a against a non-resident, or you assign or you transfer your securities to first to an Indian resident, and then the Indian resident then puts the securities to to the other to the person who has given the put option. So, but the challenge is really when you are as a non-resident transferring or having a put option against an Indian resident. That's one. Second is just be careful, because transfer from a non-resident to a non-resident Indian requires regulatory approval. Non-resident Indian means non-resident Indian as you understand it to be. It means an Indian passport holder who's not been resident for 182 days and all that. But it also means a PIO, which means that if your wife, father, grandfather, anyone was an NRI at any point in time, then you also technically become a PIO. You become a PIO, which means that you also become NRI. That means, so therefore, as a non-resident, you want to transfer your shares to NRI or PIO. PIO also means by being a PIO, you are deemed to be an NRI. It requires prior RBI approval. Sometimes people miss out on that. Third is, in terms of certain sectors, just be careful on how you are planning your exit. Say, for instance, I'll give you one example in the real estate space. There is there is now a requirement that, you can exit after holding the investment for either 3 years or completing the trunk infrastructure. Now, technically, you can exit after 3 years, but if you've come into a project, not done anything at all, right, and then you're exiting after 3 years, the government might see that as a form of speculative investment into land. So, the trick is, the approach should be actively involved. So, even if you are invested into the project, you could not do much because the Indian developer was not doing much. Your board meetings, etc., your correspondence should reflect the fact that you've been actively involved, asking him, what's happening, and you're not speculative. It should not be seen as if you just came into the company, stayed there for 3 years, and now you're simply exiting after 3 years, making a gain from the project, right? So, stick to the spirit of the regulation. The other, I think, challenge which now comes up for some of the existing private equity investors is that, it's a regulatory requirement that before you are going for an IPO, your convertible pref must be converted into common equity. Now, when it gets converted into, so let's say you're coming from Mauritius, and this is specifically important for Mauritius, because before the IPO, you'll have to convert your convertible pref into equity. Now, the moment you convert into equity, there's no act-like conversion. You're actually given fresh equity is being issued to you, right? So and if that is happening after 2017, even though your preference shares are held by you prior April 2017, but if your conversion is happening after 2017, your grandfathering falls away. Then whenever you sell your equity, of course, if you're selling it on the floor of the stock exchange and you're paying securities transaction tax and all, you're exempted from long-term capital gains. But if you're doing a private trade or anything else on that equity, you will be subjected to Indian tax at the rate of 10%. The other is, sometimes if the IPOs and all are a bit of a challenge in happening, there are certain other ways in which, exits, can be achieved. One is, of course, through conversion into GDRs. If Indian exchanges are not doing well, you can always, now even private companies can have their DRs listed offshore. And if you are, and just, important to note that if there is a transfer or deposit receipts on the floor of a stock exchange, then there is no tax in India. So it doesn't matter whether you're from Mauritius, US or wherever, transfer of DRs on the floor is completely tax exempt. So that's another way of exiting. The last option, we call it externalization. It's also common in US called as inversion. You can flip the ownership, and we've done it for a very large e-commerce giant in India and a couple of others. And you can flip the ownership such that the Indian operating company actually becomes a subsidiary of a global holding company. Then you can list the global holding company abroad, which can be easier. And of course, with such kind of flip externalizations or inversions, you also get substantial other benefits like cheaper leverage abroad and all of it. So I think those are some of the ways to structure your exits right from a regulatory and a tax standpoint.
Thank you. Very quickly, let's go to Aishwarya. You've done a lot of financial services deals, and what are the exit challenges in particularly financial services sector?
Sure. So I don't want to stand between you and evening cocktails, so I will keep it short. But I think the unique challenge in the financial services space is that it is so heavily regulated. And so any exit then involves a lot more regulatory interface and oversight than in most other sectors, right? So we haven't seen a lot of exits in the banking and financial services sector compared to the other sectors. And, a function of it might just be that many of these investments were made pre-2008, for example, and so it's a hangover of, the credit crisis, etc. So I think the approach that a lot of the PE investors that we advise are taking is, okay, in 2016, let's wait and watch what happens in the BFSI space, and then we will take a call accordingly. The one factor that I would keep in mind, which is a specific exit challenge in this sector, is really what I call the multiplicity of licenses issue. When you're exiting through an M&A transaction, for example, a lot of the exits in this space are structured not so much as IPOs, except if you consider microfinance, but it's a lot of secondary sales, it's a lot of strategic sales. So the two things that become important there are, A, what is the track record of the acquirer, especially if it's a change of control transaction, and secondly is multiplicity of licenses. So for example, if you are exiting through a merger, let's say, with another player in the same industry, and you have the same broker-dealer licenses, you have the same non-banking financial services licenses, how are you going to give up one license, streamline the businesses, etc.? And that is something that the regulators are very concerned about. They don't like the fact that you have multiple NBFCs, right? So how are you going to then merge the businesses, give up licenses, becomes a key challenge, and does tend to delay the deal-making process.
Yeah. Okay, I think anything you want to say? But last, let me ask you a question, right? So, basically, in India, tax environment, has always been challenging thing. Has there been some change? Has some more predictability come in now with the Modi government? And what are the typical some tax challenges you see while negotiating a deal? If you can be a little quick. This is the last questions, then you definitely will have cocktails.
Sure. So I think some predictability has come in, but that's more for the investments. I would say the predictability is more on the negative side for investments made post 1st April 2017, because there you are sure that you have to pay tax. For investments which have been grandfathered, which is before 31st March 2017, there the question still remains, even though the treaty is very clear that Mauritius only has the right to tax it, there is still a challenge which you always face while negotiating deals on whether the Mauritius entity, which is the seller, has sufficient substance to claim the treaty benefits. So it's a very contrarian view. People feel that all investments have been grandfathered, no issue. But purely from a predictability perspective, you are much better off predicting that you have to pay 10% tax. Life is simple, no tax litigation, and you can do other better things in life rather than litigating with Indian tax authorities. But if you have made the investment before that, then yes, you will get into discussions whether this will be taxable, not taxable. And that's where it becomes important on how do you negotiate tax indemnity. We almost spend 30 to 40% time on a deal negotiating tax indemnity, because this is the most important part of the deal. And the way the Indian laws are worded, in India, when a seller earns capital gains, the liability to deduct that tax is on the buyer. So not many people know that Vodafone, which is being chased by the Indian tax department, was the buyer of the shares, not the seller of the shares. So the capital gains were earned by Hutch, but the tax liability is on Vodafone, which was the buyer. And that's where it becomes important for the buyer that when you are negotiating the deal, you make sufficient provision for the tax amount in case tomorrow a few liability comes up for paying the tax amount. And what we have seen here is multiple ways in which this is being dealt. One is the tax indemnity, which the seller gives to the buyer in case there is any claim which comes up within a period of 7 years from the date of closing of the transaction. Then the seller will indemnify the buyer for the tax liability amount. This is, I would say, 8 to 9 out of 10 transactions, tax indemnity is agreed as a solution to address the tax withholding issue. We have also seen situations where there is a holdback which is done by the buyer for the amount equivalent to the tax before making payment of the purchase consideration to the seller. And typically the first tax scrutiny in India happens within 30 to 33 months from the end of the financial in which the transaction takes place. So if within that period there is no tax claim, then the holdback amount is released to the seller. If there is a tax claim, then the holdback amount, depending on whether the liability crystallizes, goes back to the buyer. We have also seen escrows which are there. We have also seen tax opinions which are issued by law firms to opine on the availability of the treaty benefits. Advance ruling, which is equivalent to private letter ruling in the US, is also a mechanism which is available where you can get certainty on your tax liability in future. But unfortunately, this time period, which was earlier 6 to 9 months, has now got extended to at least as long as 18 to 36 months. So this has no longer getting a private letter ruling is no longer an option in transactions because you want to close the transaction fast. Now, this is the mechanism. Now, the biggest problem which is faced in tax indemnity is the Indian tax department can come for a period of 7 years from the date of the transaction for a claim with a claim notice. But at the same time, if you see, most of the private equity funds are limited life funds. So you have a life of 8 to 10 years. Typically 8 years extendable by 1 year each, subject to the investor's supermajority approval. Now, what happens is the typical horizon of an investment is minimum 5 to 7 years. So if you are selling your investment at the end of 7 or 8 years, that means you only have 2 years of your fund life which is left. But at the same time, the tax department can come for a period of 7 years from the date of the transaction. So how do you bridge the gap for that period of 5 years where the fund would be wound up because all the investments have been exited? At the same time, the tax department can still come after the buyer. So what is the recourse to the buyer? And this is where we spend maximum time on, one is identifying the right entity within the seller group, which can still continue, which is something which is like the parent of the fund or the main GP entity if they are willing to backstop the indemnity. But typically we have seen GP entities are not very forthcoming to take on this liability, because as GP they only get 20% of profit in case of carry, versus here we are talking about the full liability. So that's one. Second, what we have seen is a tax insurance, and this is something which is becoming quite popular, where AIG, which typically insures most of the tax insurance products, AIG has been insuring some of the taxes, and in case there is some liability which comes up on the tax for a premium between 5 to 7% of the cover, AIG insures the tax amount. So the buyer does not have to worry. AIG will pay the amount. The seller does not have to worry. It can wind up as per the fund documents, and both parties are happy for a certain premium which they pay to the insurance company. So broadly, this is something which we have seen on the tax indemnity and tax withholding side, and hopefully maybe I think this will continue till 2020, because investment made in 2015-16 would take another 5 or 6 years, and because they are grandfathered, this issue will still continue for another 4 or 5 years. But maybe after 7-8 years we may not face this issue, but that's too long.
Anyway, thanks a lot. Any question, any comment, anything like that? I just want to make sure everybody is given opportunity. Yeah, Jay.
So there is a differential in the ordinary income tax rate for foreign companies and domestic companies. With all the changes taking place, is that also a subject which might undergo change so that the foreign company is treated in the same fashion as a domestic company?
So
Unlikely, because you see the way in which foreign companies are taxed, in some cases they are better off than the domestic company.
Only surcharge?
Many a times, okay, like royalties, technical fees and other kind of stuff, it's just 10%. Indian companies taxed at 34%. The reason why there is differential in tax is that Indian company first pays, say, 35% tax, let's put it this way, right? And when dividends are declared, again, there is a tax, right? So if you put combined tax effect on Indian company as well, is how much? 35%, plus if you say 65% is balance, I won't go into other details. And on that you pay another 20%. In some circumstances even 30%, but less 20%. So 35% plus remaining 65% if distributed as dividend will give you about 10-12% additional. So 34-35% plus 10% is 45%. Okay, so total tax is 45%. If there is a foreign company but no subsidiary in India, what happens? They earn profit, take money abroad, and then declare dividends outside. So those dividends get taxed, untaxed in the hands of foreign shareholders. So that's why in India, foreign companies, when there are branches, they are taxed at a higher rate of about 45% to equalize the same situation as in subsidiary company declaring the dividend. This is broadly the framework, but in many cases, it's flat rate, like 10%, sometimes 7.5%, reduced further by tax treaty, like 7.5% interest, right? Indian companies pay 34%. You can decide what rate of tax you want to pay. So it all depends as to, but I believe there is going to be more refinement in the Indian tax system. Tax rates will drop further from 34% to 25% or something like that. Jetli already mentioned about that. So once tax rates begin to come down, some of these issues will also disappear. So that's a little bit on the whole thing.
Interestingly, if you see, foreign companies are much better off than Indian companies, because if the Indian companies are getting a better treatment than foreign companies, the foreign companies can go under the tax treaty between the foreign country and India under the non-discrimination article. But the reverse is not true. Indian companies, they can't take benefit of the treaty, and they'll be, the same example with Nishith gave, where if the foreign company has a branch in India, it won't pay more than 42-43% tax, versus the foreign company has a subsidiary in India, together with the Indian subsidiaries corporate tax plus the dividend distribution tax, it could be over 45%. But they can't do anything because they don't have the benefit of the treaty.
So you all NRIs, you are better off. We poor Indians, have to suffer. But anyway, we do it for the benefit of you all. And with this words, you don't want to stretch too much because you don't like concluding statements and stuff like that. But I hope the day was useful. You all have been very kind. And we have already given you homework. So when you come next year, you got all these books with you. Also, M&A Lab, I think that tells you a lot of stories. And these are very, very intensive case studies. And there are quite a few case studies you will find on our knowledge site. These are case studies on M&A that are examined from strategic, legal, and tax perspective. Not only Indian legal, but also we have comparative element into that. So maybe this will be to some extent useful. If you're not interested in that boring thing, then there are things like driverless car and the IoT and some futuristic thing. If that is not, then at least there is education paper, so you can learn something. So we are trying to see as many things that we can provide you a pleasure. I hope all of you enjoyed the day. I know it's been very long. You've been very, very kind, and I really want to appreciate your patience, and we are very happy that you have been with us until the end. I think thank you so much. Thank you very much. Thank you. And now I think cocktail is open, and really you all deserve a lot more alcohol than perhaps, if you would not have to stay whole day. Thank you.